Arrest, Search, and Seizure by Hubert E. Dax. Brooke Tibbs. This book is sponsored by the Milwaukee Policemen's Protective Association and is presented with its compliments to Lawrence C. Bailey. Arrest, Search and Seizure by Hubert E. Dax, Inspector of Police, former Director of Milwaukee Police Training School, and Brooke Tibbs, former Special Assistant District Attorney, Milwaukee County, Yale University, AB, University of Wisconsin, LLB. Approved by Milwaukee Police Department and Milwaukee Policemen's Protective Association. Forward. Never, during any similar period in the history of the civilized world, has so much progress been made in the development of police techniques and procedures as during the past few decades. Much of this progress must be attributed to the efforts of enlightened and forward-thinking members of the law enforcement profession, men who place the interests of their profession and the welfare of our nation ahead of personal interests. They have accomplished a great deal. They have made available to law enforcement officers much valuable information, painstakingly gathered through the years. They were men who were not satisfied to leave well enough alone, largely because they never considered conditions, as they found them in the field of police operation, quite good enough. They had the vision to see that changing conditions in economics, in standards of living, and in popular thought made necessary commensurate changes in the application of police techniques and procedures. This book is a further and important contribution to the cause of sound and effective law enforcement. It deals with one of the most important phases of police operation, namely, the making of arrests, searches and seizures. Very few law enforcement officers, when making such arrests, were ever as sure of themselves as they might have been concerning the extent of, or limitations, upon their authority, in any particular case. The result was that in a deplorably large number of cases, police officers either failed to take full advantage of their authority, or exceeded it. When this happened, the defense attorneys, who were, of course, more familiar with the law, took full advantage of the officers' deficiencies. Officers not properly informed with respect to the subject were often haunted by the fear of civil suits for false arrest, or at least of losing their cases in court, only because they neglected to do what they might have done with full legal sanction at the time of the arrest, or did what they had no legal right to do at such time. It is for the purpose of fortifying all police officers with the knowledge essential to them when making arrests that this book has been prepared and published. Officers who study it will know just what they may or may not do when making arrests, searches and seizures, under various circumstances and for various offenses, and they will enjoy the confidence and security which will be theirs as a result of knowing that they have acted within the law, have taken full advantage of the authority vested in them by the law, and safeguarded the legal rights of all with whom they dealt, as well as their own. It must follow that criticism by the public, by the press and by the courts will be materially reduced, if not completely eliminated, and the reputation of the agency in which they serve will be enhanced. No book is of value unless it is read, and this book is no exception. Those who take the trouble to read and study it will find in a surprisingly short time that it is one of the most valuable publications that has ever come into the hands of the practical law enforcement officer. Serious-minded officers will find that it will improve their own status as officers and will reflect credit upon themselves, their community, and upon the police profession. John W. Polson, Chief of Police, Milwaukee Police Department, Milwaukee, December 1945. Table of Contents. Introduction. Chapter 1. Arrests generally. Chapter 2. Arrests without warrant, felonies. Chapter 3. Arrests without warrant, breach the peace, other misdemeanors. Chapter 4. Arrests under warrant. Chapter 5. Use of force. Chapter 6. Place of arrest, fresh pursuit. Chapter 7. Entry of land and buildings in arrest. Chapter 8. Summoning aid and commandeering property. Chapter 9. Entrapment. Chapter 10. Privilege from arrest. Chapter 11. Treatment of prisoners. Chapter 12. Search and seizure generally. Chapter 13. Search and seizure, incident to arrest. Chapter 14. Search warrants. Chapter 15. Seizure of contraband. Conclusion. Arrest, search, and seizure. Introduction. One of the highest duties of police officers is to know and follow the law. As one court recently said, those charged with law enforcement should be, in their relations with those accused of crime, the very personification of lawfulness. The principal legal problems which confront the police are the power of arrest, and the related power of search and seizure. This book is intended to provide peace officers with a better understanding of the law in these regards. Authority and comment is contained in the footnotes. Officers of the law are generally referred to as peace officers in more recent statutes. A peace officer has been defined as a person designated by public authority, whose duty it is to keep the peace and arrest persons guilty or suspected of crime. The term includes policemen of a city, town or village, sheriffs and their deputies, marshals and constables. The power of the ordinary peace officer to arrest and to seize does not seem to have been conferred originally by statute. These powers, including of course the power to arrest, are in this country thought to inhere in these officers, sheriff, constables, watchmen, except in so far as they may be limited by statute. In the city of Milwaukee, the duties of police officers are such as shall be prescribed by the Common Council for the preservation of the public peace and the good order and health of the city. Their powers are those of constables, at common law, and all powers given to constables by the law of the state. The powers of constables, at common law, were to keep the peace, to act as peace officer, aside from ministerial duties for courts and justices of the peace, keeping the peace and order, to be vigilant, to preserve the peace, to prevent the commission of crime, and to arrest all offenders who might be arrested without warrant, and to procure warrants in other instances of crime committed. By Wisconsin statute, the duties of a constable are to cause to be prosecuted all violations of law of which he has knowledge or information, to perform all other duties required by any law. Peace officers may sometimes feel that they are unreasonably hampered by the law governing arrests, that such law gives the criminals unfair advantages over the police. It must be remembered, however, that, although this law may seem to shield criminals, its primary purpose is to protect innocent persons and prevent their conviction, even at the risk of permitting the guilty to escape punishment. Under our system of government, every person accused of crime is considered innocent until proven guilty, and is entitled to all the law's protection. This sentiment was expressed by Sir William Blackstone when he said, "It is better that 10 guilty persons escape, than that one innocent suffer." History has shown that such protection is necessary to prevent indiscriminate arrests and abuse of governmental power, that vast power, which includes police power, and under which all criminal law finds its warrant. In view of these legal provisions, it is important that police officers, in making arrest and in testifying in court, so conduct themselves that the guilt of the accused will be apparent to all. It is obviously vital to take the greatest of pains in handling a case for presentation in court. It is most essential that police officers know the law of arrest and of search and seizure. It is also desirable that they have an understanding of the general safeguards for persons accused of crime. A person accused of crime is afforded constitutional protection in various ways. An accused person cannot be tried twice for the same offense. He cannot be compelled to be a witness against himself. He is entitled to be represented by counsel, and if he is without funds, the county will provide counsel at its expense. He has the right of trial by jury. He is generally entitled to be released on bail, and such bail requirement may not be excessive. He has the right to compel his accusers, and other witnesses, to face him in court. He may have subpoena to compel attendance of witnesses in his behalf. The accused is further protected by the statutes of limitations. Generally, warrants for misdemeanors must be issued within 3 years, and for felonies, other than murder, within 6 years after the offense, although warrants for murder may be issued at any time. Various other rights of the accused include the filing of affidavit of prejudice against a sitting judge, and change of venue, that is of the place of trial. Police officers should bear in mind the general nature of crime. A crime is a wrong which the government notices as injurious to the public and punishes in what is called a criminal proceeding. The more serious crimes, that is, those punishable by imprisonment in the state prison, are termed felonies. Other crimes are termed misdemeanors. In Wisconsin, crimes are punishable principally by fine or by imprisonment subject to possible probation. In order to enforce the criminal law, police officers, and in limited situations, civilians, are authorized to make arrest. Such arrest means taking another into custody for the purpose of bringing the other before a court, or of otherwise securing the administration of the law. Arrests are made in 2 ways, without warrant, or before issuance of warrant, and with warrant. Right to make arrest depends upon the nature of the crime involved, and upon other circumstances. Further, in enforcement of criminal law, police officers are authorized to make search of persons and of property, and to seize property, both in connection with arrest and otherwise, but again subject to restrictions imposed by law. The law of arrest and of search and seizure is based upon federal and state constitutions, state statutes, and common law. Common law derives its authority not from express enactments of the legislative power, like the statute law, but from the fact that it has existed and has been accepted as the law from time immemorial. It is preserved and evidenced by judgments of the courts, applying it to particular cases as they arise. Constitutional provisions which relate to these matters, and which apply to police officers of the United States and of the state government, are found in the 4th, 5th, and 8th Amendments of the United States Constitution, and in Article I, Sections 4 to 9 and 11 of the Wisconsin Constitution. And the 14th Amendment to the Federal Constitution is of great importance, nor shall any state deprive any person of life, liberty, and property, without due process of law. It may also be noted that arrests are also made under civil process, that is, persons are sometimes taken into custody under special writs and orders for enforcement of civil rights, as distinguished from enforcement of criminal law. However, no 2 such orders are alike, and the law is strict as to their issuance. Before making such arrests, it is desirable that police officers first obtain legal opinion from the district or city attorney with respect to the validity and effect of the particular writ or order involved. A good working knowledge of the law of arrest is important to every police officer. Such knowledge is desirable in order to avoid errors or irregularities in making an arrest, as may later lead to the discharge of the prisoner by the court, also to avoid possible civil and criminal responsibility for the officer's action. But most important, such understanding is vital to the making of all decisions involving the arrest and detention of persons suspected of crime, and the seizure of property. Police officers are constantly called upon to make such decisions. Knowledge of the rules of arrest and of search and seizure is the officer's best assurance that he will properly perform his duties.